Thank you, David, ladies and gentlemen. I'm particularly pleased to introduce today's webinar entitled "The Justice for Sarah Halimi Amid New Antisemitism Wave in Europe," with Oudy Bloch and Muriel Ouaknine-Melki, two lawyers representing the family of Sarah Halimi. They both belong to the OGE, European Jewish Organization. Muriel is the president and Oudy the vice president of this organization, an organization which gathers 55 lawyers who fight all forms of anti-Semitism and already solved more than 3,000 cases, which is a lot. In a difficult environment where it seems more complicated than ever to be Jewish in France, the European Jewish Organization endeavors to give hope and confidence to those who have lost faith in France, to restore courage and strength to those suffering the tragedy of anti-Semitism, reinitialize this distended bond between the Jews of France and their nation before a lasting disenchantment appears. The OGE give itself this mission like a fair and legitimate fight. The work of OGE and ELNET is complementary. They deal with legal issues while we treat political matters. We are friends and partners and work together on several issues, especially the fight against BDS. And I could say that in this fight, our friends of BDS are very successful. And if you have questions about that, also they will be able to answer all the questions you will have. So we have today two very special speakers. Muriel Ouaknine-Melki is a member of the Paris Bar since 25 years. She specializes in criminal matters. She was the counsel for the civil parties in the case of Ilan Halimi, you remember, more than 15 years ago, Otzara Torah, the Jewish school in Toulouse, Hyper Kasher, and since 4 years in the case of Sarah Halimi. She taught at the Bar Training School of Paris, and actually she trains the gendarmes, the police officers, and the judge to fight against anti-Semitism. Oudy Bloch is a member of the Paris and New York bars and specializes in criminal law, intellectual property, and contract law. He is graduate of UCLA in Los Angeles. Oudy Bloch was a lecturer at Paris 10, Nanterre. He's a member of several humanitarian associations and is the one among us that is speaking a very good English. So we are very happy to have him with us today to speak about this very important issue. So Sarah Halimi's case moved a lot of people worldwide and not only Jews. So we will discuss today this case and try to understand the instruction failure. So Oudy and Muriel, my first question is like that. The various failures and procrastinations that are difficult to understand are and will probably remain a textbook case. In this troubled time between anger, sadness, and desolation, the Atal Halimi family legitimately demanded that justice be served on behalf of the French people, but also to mourn. So could you explain more in detail all the instruction failure that you had to face during this trial? The floor is yours.
Thank you, everybody. Thank you, Aryeh. Thank you, everybody. It's a great pleasure to be with you tonight. Well, tonight for us and today for many of you. Before getting into our conference, I would like just to say a few words. We, Muriel and I, are, as Aryeh told you, we are representing William Atal, who's the brother of late Sarah Halimi. We're working with two other colleagues of ours, Nicolas Benoit and Stephanie Cohen, and they're representing William Atal's wife. And we have a lawyer who specialized to intervene before the Supreme Court. And her name is Julie Buc-Lamont, and she's the one who's been with us since we began. We are, as I told you, all members of the European Jewish Organization. We're about 50 lawyers. We all work pro bono on all the cases we have because we consider that as long as a Jew is in danger for being a Jew, we must intervene, and we do it completely freely. So as many of you know, or maybe don't know, Sarah Halimi was assaulted at night in her apartment on April the 3rd, 2017, and severely beaten and then defenestrated by her neighbor, Mr. Traoré. And today, Kobili Traoré is considered to be criminally irresponsible for the abolition of his discernment by the time of the crime. But to get there, the investigation and the proceeding have had their share of failures. Muriel is going to tell you about those failures, but just a few words very quickly on the French procedure, because it's very different from the American procedures and the Israeli one. In France, we have investigating judges for criminal matters. They are in charge of the investigation. They control the police work. There are several layers in the public prosecutor's office. Sorry. There is a public prosecutor's office in every criminal court. There is another one in every court of appeal. They are called the General Public Prosecutor's Office. And a last one, Public Prosecutor's Office in the Supreme Court. The investigating chamber to which the case has been referred by the investigating chamber is part of the Court of Appeal. It is the Court of Appeal for investigating matters. I'm making those little clarifications because we're going to talk about it. So in order for you not to get lost in the proceedings, we thought it was useful. And so the investigating judges were in charge of that investigation, and we believe that there has been various failures, and it began as soon as the opening of the investigation, and Muriel is going to tell you about those failures.
Hi, hello everybody. Nice to meet you and to see that we are so many tonight. Well, the prosecutor's office opened the procedure without the aggravating circumstance of anti-Semitism, while the testimonies collected immediately by the police pointed very clearly to an anti-Semitic crime. We have been fighting for 6 months. 6 months for the public prosecutor's office to issue a supplementary indictment, including the aggravating circumstance of anti-Semitism, and 4 months for the investigating judge to put Kobili Traoré under examination in a supplementary manner on this basis. And to do so, the judge considered that the grounds for holding the aggravating circumstance of anti-Semitism were the sight of a Jewish candlestick and of a prior book written in Hebrew that would have increased Kobili Traoré's wages, which is very pretty light. The investigating judge could have taken into account the choice of the victim, whom Kobili Traoré knew to be Jewish. He had been living under her apartment for 20 years. He knew her. The surahs of the Quran, the yelling of Allah Akbar, the word Shaitan, the fact that he attended the Omar Mosque, which is known for being Salafist. No, none of that. And when the investigation judge decided to refer the case to the investigating chamber, she gave up the aggravating circumstance of anti-Semitism. One is entitled to ask some questions. The Sarah Halimi case is symbolic, really symbolic. But we deal with a lot of cases in which the anti-Semitic character is retained with great difficulty. Training problem of interest, maybe you should explain us, Oudy, those problems that we meet.
Yeah. The Sarah Halimi case is, as Muriel told you, is very symbolic because it was a horrible murder that you all know about now. But we at the European Jewish Organization, we deal with a lot of cases, Arya told you. And we've noticed that we met loads of difficulties regarding the qualification of anti-Semitism. I'm going to give you a couple of examples. A few years ago, a young Jewish boy was assaulted in the streets. He was wearing a yarmulke. He was assaulted, insulted as a dirty Jew, badly injured, and the police officers still wondered if it was an anti-Semitic case. The young Jewish boy was wearing a yarmulke, and he was it out of a Jewish school that he was? It was out of a Jewish school that he got assaulted, and nobody within the police forces wondered, thought that it could be an anti-Semitic assault. A few months ago, in Paris, a young man painted huge swastikas with red paint on various Parisian buildings, and the public prosecutor told us that he didn't think it was anti-Semitic because the swastikas were not painted on synagogues. And so we had to explain him that wherever it is painted, a swastika remains a swastika. And the funny thing in that case, which is not funny at all, is that the one who painted those swastikas eventually was considered criminally irresponsible for because the psychiatric experts considered that he suffered from an abolition of the discernment. And it is the exact same case with Kabili Traoré, but the case is much more important with the Sarah Halimi. So we have these problems with police officers because maybe they're not trained well enough. They don't know, they can't spot easily enough when there is an anti-Semitic assault. We have, but what is even a bigger problem is that we have the same issue with judges, public prosecutors, and judges who are ruling in criminal courts. And that's why, and Muriel is going to tell you about, that's when we've been asked to intervene with the police forces and the judges for training. Muriel.
Yes, a few months ago we decided, because we were asked about it by the government, to train police officers and judges about the anti-Semitic characters, because for us it's very important to ask the right question at the beginning of the investigation. So that's why we do it, and we believe that it's important to do it. Those first investigation in the case of Sarah Halimi is also mattered by the reconstruction. The reconstruction wasn't agreed by the judge. It was refused. This is the basis in France, and I think also in your country, it's the basis in criminal cases. Investigation judge said no. Said no reconstruction in this case, in the case of Sarah Halimi, because Kabili Traoré had some
health issues.
Issues, that's it. And because he confessed everything. He told all the truth for the judge. And for her, she didn't need to go to get a reconstruction of crime scene, and she decided to not do it. Even if the psychiatrists were okay for this, even if the public prosecutor was also okay, even if the defense attorney was okay, and even Kobili Traoré himself was okay and mentioned it in front of the investigating chamber that he owed it to the family, but still, our request was rejected. So in this case, we had a lot of problems. And this investigation was conducted in spite of common sense. We do not have, in this case, telephone expertise. We do not have any information about the negotiation. We know that Kobili Traoré talked to his mother over the phone, and we do not have any information about that. We know that Kobili Traoré used to go to Omar Mosque, and we do not have any information about that also. We also asked to qualify this act of torture, and it was also refused.
So by the end of the day, at the end of the investigation, the investigating judge can take various decisions. And the judges, because there were two actually, decided to refer the case to the investigating chamber, considering that there was a possibility for Kobili Traoré to be insane, quote unquote. And they asked the investigating chamber to rule on that issue, and that's what the investigating chamber did, and they did it on the basis of the psychiatrist expertise that were done during the investigation. Now, it is a very important point because that's why we got to that results, because of the expertise. In France, we often hear that the three psychiatric expertise were unanimous, concordant, and that the judge could only do one thing, is to follow the decisions. Problem is, they were not unanimous and not concordant. In criminal cases, and especially in that cases, it's very usual to get a psychiatric expertise of the murderer. So the first one was done by one of the most famous psychiatrists in France, specialized to intervene in courts. And he concluded that Kobili Traoré suffered from an acute delirious puff because he smoked too much cannabis, which resulted in an alteration of discernment. And that's an important point because the alteration implies the possibility of an indictment in the criminal court. So that expert concluded to an alteration of the discernment and the existence of an anti-Semitic character of the crime. The second expertise, and that's another important point. We didn't ask for a second expertise. The public prosecutor didn't ask for a second expertise. Kobili Traoré's lawyer didn't ask for a second expertise. The judge decided on her own to have another expertise, psychiatric expertise, because I don't know why. Apparently she was not happy with the first one for whatever reason that I don't know. So she ordered a second expertise, and that second expertise leaned inversely towards an acute delirious puff as well, but which resulted into an abolition of discernment. Abolition of discernment, no conscience at all, no grip on reality, and that's why the judge began thinking about criminal irresponsibility. But the second expertise concluded to an abolition of discernment with a chronic psychosis and the existence of an anti-Semitic character. And there has been a third expertise, which leaned also towards the abolition of discernment, but without the chronic psychosis and without the anti-Semitic character. So this to tell you that those expertise were not unanimous at all. And one of the experts of the second expert opinion acknowledged before the investigating chamber that he had made a mistake in his diagnosis and submitted to the general opinion that there was no psychiatric pathology for Kobali Traoré. The second expertise was made in May 2018. The hearing before the investigating chamber was on November 2019, so it was 18 months after. And at that time, Kobali Traoré was fine. He was speaking very normally. He was very calm. He was understanding everything we would say. And so the expert acknowledged just there in court that he had made a mistake on this psychiatric psychosis, but he considered that it didn't change the result of his expertise. And the one of the experts of the third expertise recognized, acknowledged in front of the court that Kobali Traoré could have had peaks of consciousness during the crime. But then if there is consciousness, there is no abolition of discernment because it's contrary one to the other. That's why we believe that the investigating chamber could not rule as it did, affirming, and I quote, that there was no doubt about the existence in Kobali Traoré's mind at the time of the crime of a disorder having abolished the discernment. It couldn't say so, but it did. It couldn't say so because there are three expertise and not one agrees with the other. A few weeks later, an expert of the third expert opinion who had concluded to the abolition of discernment gave an interview in a newspaper in France and said that, well, finally, one can defend the two conclusions, alteration, abolition, and he could have said otherwise. So, like, it was no big deal, but it was a big deal for us because the courts decided on the basis of those expertise that decided that since Kobali Traoré was supposedly insane, well, he was criminally irresponsible.
So if I may, Oudy, we in this case we see the issue of the instruction failures. We see the problem with the expertise, and you said three different expertise that were not unanimous. That means that it was possible for the judge to decide in another way. But what is after that? Before going to what was the result of the Court of Cassation, what is your assessment as a lawyer in charge of this case about the way the judge conducted this investigation and this instruction in this case? Is it normal? Do we have some other example that shows that it's happened in other cases like that? Or what was at this time your assessment when you saw all these dysfunctional situation? What did you feel at this time?
Well, the thing is, we did not understand why it was going so wrong. We went to see the judge, and we had, at the beginning, we had pretty good relations with the judge. Nevertheless, when we asked for investigating actions, and we were, and those requests were rejected by both the investigating judge and the investigating chamber, the upper level, we could not understand why. It was making no sense whatsoever. So we don't know, to tell you the truth, we don't know if there is an ideological, political, racial problem. We don't know. We don't know what they think. What we do know is that we know that justice in France as an institution is not anti-Semitic. That's for sure. It doesn't mean nothing to say that French justice would be anti-Semitic. It's not true. Now, could judges be anti-Semites themselves? Why not? I mean, there are anti-Semites everywhere, with the lawyers, the bakers, the police, the judges, the firefighters, and whatnot. I don't know, but we were pretty pretty surprised of the way the investigation was conducted, and we fought a lot in front of the court to get things right. And people often tell us that they don't understand why we are so upset, because insane people should not be brought into trial. We agree with that. We don't want insane people to be brought into trial. But what we believe is that Kobili Traoré is not insane, was not insane, and is still not insane. And we know that for sure, because in front of the investigating chamber, he was already benefited from a significant decrease of its medication, because he didn't need that kind of medication anymore. So we know he's feeling better, and we know that he is not in a unit for difficult patients, and that's why we're so upset.
We will go back. We will go back later to the. We will go back later to the situation of Kobili Traoré, but let's move to the decision that was made by the Court of Cassation. What is the Supreme Court, the equivalent of the Supreme Court in France, and you made an appeal to this Supreme Court, and we were, most of us, sure that this Supreme Court would break the decision of the decision of the court, and then we will have another trial, and Kobili Traoré would have been judged in a normal way. But what went wrong in this situation? Because we all of us were expecting that the Cour de Cassation will break the case. So what went wrong? How can you explain that?
Well, what went wrong is that the Supreme Court set the law, basically. It could have done otherwise. To make a long story short, the Supreme Court said the law does not make a difference between the origins of the abolition of discernment, whether it is use of drugs, use of alcohol, mental illness. It doesn't matter. As long as the discernment is abolished, the person is considered to be insane and criminally irresponsible. And that's what the court said. And the court said, where the law does not make that distinction, I, judge, will not make it, which is the actual positive law in France. But the Supreme Court does not only says the law, it creates the law when it wants to do it. So the Supreme Court could have done it otherwise. We worked a lot. Julie Buclamont, before the Supreme Court, gave grounds to the Supreme Court to judge otherwise, and it did not. What we believe is that Supreme Court was not very, very courageous on that one, and we regret it. We regret, and then I'll let Muriel give you her opinion. We regret that for the Supreme Court, someone who puts himself in a state of no longer being able to control his own actions is not responsible for what he or she has done. Kobili Traoré used a lot of drugs. He was using drugs since he was 14 years old. He was 27 years old when the crime happened. He was using drugs, smoking every day, smoking up to 15 joints a day. He experimented paranoia, a crisis of rage. He knew the effects of cannabis on him, on his mind. He should have known. He should have known that he could have modified his discernment, and basically that's why people using drugs use drugs, to have a modification of their conscience. Now, he should be held responsible for that, and the Supreme Court could have ruled that way if it wanted. Muriel.
Yes, I'm sure about that. I'm sure that the Supreme Court should have a choice. And I was like you, Arié. I really think that she should have done another way, take another way. And we did believe that the Supreme Court had the legal means to render another decision, to make the law evolve with society. And to answer to your question, Arié, we have to talk about a lot of things about anti-Semitism and the justice. I do not think that there is anti-Semitism about all the justice, but I really think that we have a problem with some of the judges, sure, for that. We also have problem for police, with the police. And in this case, in the case of Sarah Halimi, we didn't talk about it tonight, but we have also the problem to understand why the police did not help Sarah Halimi. As everybody knows, the police was present, was there the night of the 4th of April, and they do anything. They do nothing. They do nothing to help Sarah Halimi. And this is a question, and this is a problem also for the justice. We have to understand that. And when we asked for the reconstruction of the crime scene, we asked also to understand why the police did nothing this night. And we do not have this question and the answer today.
It's the most incredible thing in this case that many police officers were there and they didn't intervene, and it's just incredible.
That's incredible, but that's this case also. So we have to think about this problem, the problem with the police, to understand why this solution by the Supreme Court. So the problem with the police, maybe the problem about some judges and maybe some anti-Semitic judges in this case. After, we have the problem of the cooperate between all those judges, because in this case, we know that at the beginning, only 2 judge of investigation, only 2. After, 3 judges in the investigating chamber. And all agree with the idea that Oudy Bloch was not responsible of this act because he was insane, okay?
Supposedly.
So when we go from in front of the Supreme Court, the 12 judges of the Supreme Court had to, comment est-ce que je peux dire, casser avec la décision.
They had to overrule the decision.
Yeah. Et ils déjugent en fait.
Well, yeah. What we want to say is that 5 judges, 2 investigating judges, and the 3 judges of the investigating chambers ruled in favor of Oudy Traoré's abolition of discernment. And to overrule that decision, those decisions, the Supreme Court should have gone contrary to their colleagues. And what Muriel is saying is that maybe that's an issue, but it's not an issue in many other decisions. Why in this why?
We don't really know. And we have also another problem with the role of the government in this case. As you should know, Emmanuel Macron, our president, had some words about justice and the Sarah Halimi case. And we also think that for that,
yeah, we paid the price because Emmanuel Macron very probably believed, was sincere, saying that the victim's family deserved justice, deserved a trial to really understand. That's what we think. But to say that in public, in France, is considered by the judges as a intolerable breach in their courtyard.
And by the way, he didn't say that when he was in France. He'd say that when he was in Israel during his visit, official visit, if you remember, it was in January 2020.
Yes.
So perhaps something that could also contribute to...
Probably so, probably so. He said it twice, actually. He said it once during the commemoration of the Veldiv in 2017, in July 2017. He was fresh president-elect, and once more, you're right, Arié, during his visit in Israel, and that that had a symbolic way that probably didn't please the corporation, the judge, the institution, to the point that the general public prosecutor with the Supreme Court and the first president of the Supreme Court published an answer to Emmanuel Macron saying, Mr. President, you mind your own business and we mind ours. So maybe that didn't help our case.
Let's go to my last and perhaps the most important question. Let's speak a little bit about Oudy Traoré himself. 27 years old, Traoré is a Malian origin and French nationality, has a lengthy history of theft and violence. He is a repeat offender with 22 convictions for drug trafficking.
Correct.
And he has been convicted 22 times, so for armed robbery and drug trafficking, as I said. So today, everybody is asking himself, what can we do? What are the possible legal remedies to have a try? Is it still possible to do something, or are we condemned to see in few months, few years, Oudy Traoré free to leave the hospital where he is? Is there another option?
We hope so.
So tell us a little bit more about what you are doing now, because this is the most important, and we know that the French Parliament decided to organize an inquiry committee about this case that will be ruled by our friend, the Member of Parliament, Meir Habib. Also, we know about the new law that is to be voted in the Parliament to prevent such a situation to happen again. So tell us a little bit about that also, and about what you think that will be possible to do and what you are fighting for.
So what we're doing is, there are several questions in your question, Arié. To talk really quickly about the law, the law that is in preparation will apply for the future.
Not for Sarah Halimi.
Not for Sarah Halimi's case. So as long as we're concerned, we don't care much, because our mission as lawyers of Sarah Halimi's family is to fight for Sarah Halimi's memory. And we want a trial. We don't want, to make it really clear, we don't want Oudy Traoré to be sentenced to 30 years of prison if he was really insane at the time of his crime. What we want is have a trial so that we can have the proper answers to our questions that didn't have any answers during the course of the investigation. Now, if in France, the jury intervenes only in very serious criminal matters. And when the jury says rules on a decision, it is considered to be the decision of the people. You can make an appeal, but it's very important decision. Now, so the law is not our major preoccupation right now. What we can do is find new elements in order to obtain the reopening of the investigation. Those new elements are elements that were not known during the course of the investigation. And we're working hard to get those new elements. Could be testimonies, could be
reconstruction
of the crime scene. It could be technical investigations that didn't happen during the investigation. And maybe with the parliamentary commission that is to be put in place in a few weeks or month, maybe we could have new elements that would allow us to request for the reopening of the investigation.
And this reopening, we will ask it to the prosecutor, public prosecutor, and he will send this request to the Supreme Court. And the Supreme Court will decide if we can reopen or not.
Are there many situations like that when the court decides to reopen a case?
By twice.
Not really.
2 times. We had the Dreyfus case, that you know, and another case a few years ago.
So the chances are tiny, if I understand.
Well, what we're going to do is we're going to fight until it is over, but it's not over until it's over. So that's what we do. The other possibility, and we're working on it, is to go up to the European Court for Human Rights, because we consider that contrary to Article 6 of the European Convention, we didn't have access to a fair trial because the hearing we had in front of the investigating chamber was not a trial. It's a hearing for investigating matters. It's not a judgment. The investigating chamber does not give you a judgment.
But if we go in front of the European Court, we do not have a trial in France after. We will only have maybe a sentence for the French justice. That's it.
Yeah, the thing is, the European courts might they might give a ruling, a sentencing France, but then what?
Is there, my last question, is there a way that Kobi Traoré could be free in a few months or years from now?
For sure.
Well,
for sure. And by the way, actually, we do not know if he spent all his days in the hospital. We are not sure about that. Maybe he goes out on the day and he comes to sleep at the night. Maybe. We do not have any information about that right now. We asked for it and we wait.
Ari, to answer your question, experts have told us in the court, most of the experts, except one, told us that Kobi Traoré was crazy enough at the time of the crime not to go to jail, but not crazy enough after the crime to remain for a long time in a psychiatric asylum. So what do you want to do with that? Well, let me tell you one thing. In France, you do not bring someone insane. You don't bring him into trial, but you don't keep someone who is sane of mind in a psychiatric asylum. It doesn't work like this. So what his lawyer is going to do? Well, his lawyer, who's a pretty good lawyer, is going to ask for his release, and there will be no reason whatsoever, because he's not crazy, to keep him in a psychiatric asylum, and he will be freed. And it's not something very, it's not, how could I say, shocking when you think about this, because if you're not crazy, you're not kept in a hospital, and that's it, bottom line. And what do you want to do with that?
Absolutely. Muriel and Oudy, thank you very much